Okay. Good morning, everyone. My name is Kwame Owino. I work at the Institute of Economic Affairs, and I welcome you to our 6th webinar of the year. What we are discussing today is to give you some insights into the Constitution Amendment Bill. The press calls it the BBI law, but basically it's a Constitution Amendment Bill that we all know has been approved by 43 counties. The draft has been approved by 43 counties by yesterday. And so that means that the referendum should be in the offing. Before that, I think tomorrow afternoon, Thursday, the bill will be presented to Parliament for parliamentary discussion. But our purpose today is to try and provide insights and some public education around what is contained in the bill, what will it change, and what some of those would be implications for Kenyans as citizens generally, for businesses, but just largely so that we all know what kind of constitutional architecture will emerge if this bill comes through or if this bill is brought before Parliament. At the same time, we know that all of us have some need to really understand what would change in the constitutional landscape. So the purpose of our meeting today is to start by just going through a couple of chapters to let us understand what those chapters do. Last week, on Friday, we had a discussion on Chapter 8, which was basically on the legislature. And the reason we started with the legislature is most of the press coverage has been on what the implications of expanding the size of Parliament would be, both in terms of numbers and also in terms of, the number of legislators at the same time as the cost implication for taxpayers. So today, my two colleagues, Jacqueline Kagume and Leo Kemboi, who run the program on law and economy, we'll be discussing the Constitution Amendment Bill, but specifically review of amendments to chapters 9 and 12. Remember, the Constitution Amendment Bill has proposals for amendments of specific chapters, specific clauses in the Constitution, but they also are arranged in terms of chapters. So some of the proposals are not necessarily related to the Constitution, to the Act, but basically the function of this bill would be that it would be like an omnibus what would be changed and what the implications would be. So without further ado, I'll pass this on to my colleague Jackie, who will make a presentation on Chapter 9 and thereafter Leo on Chapter 12. Now, what we advise is please keep your cameras switched off, except for whoever is speaking, so that we give the speakers an opportunity to focus on the presentation, but more importantly, because we are recording this that when it is played, obviously it gives us better flow. And obviously we won't have to do so much editing. So that's the first. And we have two chat boxes right at the top of the menu bar. So if you have any questions, you can ask those questions as we go along. And then there'll be an opportunity for us to have Jackie and Leo to respond to them. But otherwise, thanks again for attending this meeting. And we hope it will be an opportunity to learn something new about what the contents of the Constitution Amendment Bill are. So Jackie, pass it on to you now. Thanks.
Sorry, I was on mute. Good morning, everyone. My name is Jacqueline Kagume, and I'll be making the first part of this presentation. What we'll be doing today is to discuss two chapters, the amendments in this Constitution of Kenya Amendment Bill 2020. The two chapters we are discussing today is the executive and public finance. So I'll do the first part of the presentation, discussing the amendments that relate to the executive. Then my colleague Leo will come in and discuss the amendments that relate to public finance. So for purposes of the bandwidth, so that there are no interruptions, I'll turn my video off, then just begin the presentation. So to start, the amendments that relate to the national executive according to the what we call here CAB 2, the Constitution of Kenya Amendment Bill, begin in clause 22 of the bill, and they run all the way to clause 36. So there are 14 clauses within the bill that propose to amend the chapter, which is chapter 9 on the national executive. Looking at what is stated as the main objects and the main object of the amendments that relate to the national executive, according to the bill, is to broaden, rather to expand or broaden the executive structure as it from what it currently is, in order to achieve inclusivity, cohesiveness, and unity for the benefit of the people. So, based on the feedback that I believe was received during the BBI hearings, perhaps there were suggestions. I believe there must have been suggestions to either expand the executive, because maybe they thought that may be one of the reasons that has limited or caused what people feel as lack of inclusivity in government. So you will see from the amendments that we will discuss here that effectively, most of them seem to actually expand the executive, and then it will be up to you to determine for yourself or make the decision as to whether you feel these are good or bad amendments. So in our view, it's just to provide you with our objective here is just to provide you with the facts and what the amendments propose, then you can make that decision. So if we begin with the first, which is clause 22 of this amendment bill, it proposes to amend Article 130 of the Constitution, and it adds the position of the Prime Minister and 2 Deputy Prime Ministers to the National Executive. So if you have a copy of your Constitution and you look at Clause 130, it looks at the principles and structure. Under the principles and structure of the National Executive, looking at the composition, the National Executive currently, it currently comprises of the President, the Deputy President, and the rest of the Cabinet. That is what is stated for now. But if these amendments are, if the bill is passed as is, then under Article 130, besides the people that are already there, then we will have an addition of the Prime Minister and the Deputy Prime Ministers as being part of, as forming part of the National Executive. That's the first one. Then Clause 23 proposes to amend Article 131, 1B, which also adds the Prime Minister, 2 Deputy Prime Ministers among the DP and Cabinet, and the rest of Cabinet as assistants of the President in exercising executive authority. So if you look at the functions of the President, that is under Article 131, the authority of the President, under Article 131.1, the President is required to exercise, he's the head of state and government, and he exercises the executive authority of the Republic with the assistance of the DP and the Cabinet Secretaries. So what this amendment does is, given that now there is an addition of Prime Minister and 2 Deputy Prime Ministers, then they are added there among the list of those who will assist the President to perform that specific function. You will notice that there will be a change in what is now termed as the office of the Cabinet Secretary. That will now be the profile of that office changes to Cabinet Minister. And that is again in line, because since there will be a Prime Minister, then it's only a Prime Minister and Deputy Prime Ministers, then effectively it means the rest of the Cabinet has to be renamed to ministers and assistant ministers, as we will see later. So that's clause 23. Then when we go to clause 24, clause 24 of the bill proposes to amend Article 132 of the Constitution. And here the amendment looks at under the functions of the President. Once every year, the President is required to report to Parliament in the national state of the in the State of the Nation address. Once every year, the President is required to address the nation on all measures taken and progress achieved in realization of national values referred to in Article 10, amongst other things. Amongst the other things that he's supposed to report, one of the things that had specifically been mentioned in our current constitution was that he was supposed to report on what progress has been made in terms of realization of national values. So here we see an addition to this, which states that the president will now be required to report to the nation on economic and social rights, outlined realization, progress made towards realization of economic and social rights that are provided for in Article 43. So Article 43 on economic and social rights, I think we all know what those are. We have the right to education, health, water, and housing. I can just mention them here. So it's the highest attainable standard of health, which includes the right to healthcare services, including reproductive health, adequate housing, every person has a right to be free from hunger, access to clean and safe water, social security, to education, and no person shall be denied emergency medical treatment. So while in his state of address, he's also required to report on what measures the state has made towards realization of this right. So that's clause 24, the first part of clause 24. If you look at the next clause 24b, just go back, sorry. There's an additional amendment which provides that the president shall nominate and so let me just read that. So clause 24b deletes words, the words where applicable under Article 132(2), and Article 132(2) provides that the president shall nominate and, with the approval of the National Assembly, appoint and may dismiss cabinet secretaries. So the amendment here under clause 24b is removing that requirement, or is adding the words, or rather is deleting the words where applicable. And what this does is it implies that there are instances where the president shall nominate ministers without approval of the National Assembly. So this effectively removes the vetting requirement of cabinet ministers who will be nominated from outside Parliament. We will come to the new articles that will be inserted, which have an effect on the appointment and nomination and appointment of cabinet ministers. But given that this Article 132 already mentions how the president shall appoint CSs, here it's done away with the requirement to vet cabinet ministers in some instances, because these will be ministers who will be coming from the National Assembly and who will already be members of Parliament. But in some other instances, it seems as though there may be vetting in some instances, and in some there will not. So where applicable implies that it's not in all instances where where approval by the National Assembly will be required. And then the other amendment there is changing of the word cabinet secretaries, as I had stated earlier, to cabinet ministers, to provide that uniformity in the naming. Can we go to the next? Clause 25 of the amendment bill as well, it deletes the words cabinet secretaries under Article 134(2)(c) of the Constitution, again, and just renames that to cabinet ministers. Then clause 26, it proposes to amend Article 138(8) of the Constitution. And Article 138(8) of the current Constitution looks at provides for the procedure at a presidential election. So what it does, it limits the scenarios where an election shall be cancelled and a new election held. So currently, this Article 138 provides for various scenarios which may cause an election to be cancelled and a new election held. And one of those scenarios is where the death of the candidate or the death of the death of the actual presidential candidate or the death of a deputy presidential candidate may cause for an election to be cancelled and a new one to be called. But in this instance, the amendment here removes the condition that requires the presidential election to be cancelled where a person nominated as a deputy president dies before the scheduled election. So the object states that this is to minimize or to take away some bit of uncertainty or to minimize the instances where an election has to be cancelled. So the only instance that will cause, the only deaths here that may cause for an election to be held will be for the main candidate, but not for the deputy president, for any candidate who is vying as a deputy presidential candidate. Then if we go to clause 27 of the bill, it amends Article 142 of the Constitution by deleting the word 14 and substituting the words 32. Substituting for the word 30. So Article 142 of the Constitution is on questions as to the validity of a presidential election, and currently it's provided that within 14 days after the filing of a petition under the Constitution, then the Supreme Court shall hear and determine the petition, and its decision shall be final. So it's this time that the Supreme Court has been provided, which is currently 14 days. So this amendment seeks to increase that to 30 days. And the main reason provided for that is to provide for a more realistic period of finalizing a presidential election. I think we've all seen in the past that 14 days may not have been adequate and has in many cases caused the Supreme Court to make rushed decisions or not to provide a proper, full, comprehensive judgment within that time. So they seek, and also the time for hearing and determination of this petition. So this has been increased to 30 days. I think we can all make a judgment as to whether 30 days is now sufficient or it should be more, or what views. So different people hold different views on that, but the amendment that is proposed here is to increase that time from 14 to 30 days. Go to the next. Then the amendment in clause 28 of the bill proposes to insert a new part immediately after Article 151 of our current Constitution. So immediately after Article 151, yes, of our current Constitution. So Article 151 is on removal of the deputy president. So we have Article 150 on removal of the deputy president, and then 151 on remuneration and benefits of deputy president. So after the provisions that are made regarding the president and the deputy president, then we will have this article. This clause proposes to insert a new article regarding the office of the prime minister and the deputy prime ministers. So if we look at 151A, specifically, it creates the office of the prime minister and sets out the specific roles. So if this bill is passed, then there shall be a prime minister who will be appointed by the president in accordance with Article 151B. Then the roles that are set out there is that the prime minister shall be the leader of government business. He shall oversee legislative agenda in the National Assembly. He or she, I say he, but yeah, he shall supervise execution of functions of ministries and government departments, chair cabinet meetings, or any other functions, and he may assign any functions to the office of deputy prime ministers. So that's a whole new article that has been inserted there. So it will be 151A, and then we have 151B, which then now provides for the procedure of appointment, of the Prime Minister. So the President will appoint the Prime Minister within 7 days once the President is sworn in. Within 7 days of this, he's required, or following any occurrence of vacancy in the office of the Prime Minister, then the President shall be required to nominate a Prime Minister in accordance with this article. And the Prime Minister shall be appointed from the coalition, from the party with the most members, or the coalition of a party with the most members. And a person is eligible to be nominated if the person, as a PM, only if the person is an elected member of the National Assembly and is the leader of the party with the most members. So the same article then provides that once the President makes that nomination, within 7 days of this, he's supposed to provide that nomination to the Speaker, and within 7 days of the Speaker receiving the nomination of the President, then the Speaker shall call a vote in the National Assembly to confirm the appointment of the person that has been proposed by the President. So the same article provides for that this vote shall be passed if it's supported by more than half of all the members of the National Assembly. And if this does not happen, if the National Assembly does not confirm the appointment of this person, then the largest party or coalition of parties shall, within 7 days of rejection of this nominee, designate another member to be the party leader in the National Assembly, and the other clauses will apply. Subsequently, the next clause provides that if the National Assembly does not confirm the appointment of a person proposed under Clause 5, then the President shall appoint a member who, in the President's opinion, is able to command the confidence of the National Assembly. So here we are saying that in the first instance, the President shall nominate a person for PM who is already a member of Parliament and who is from the majority party. Then, if Parliament fails to confirm this person, they shall provide a second nominee. Then, if Parliament further fails to confirm this second nominee, then the President will go ahead and appoint a third person who in his opinion is able to command the confidence of the office of the National Assembly. So I hope that is clear. Then there is a new, the next amendment proposes to insert a new article as 151C, which details how the office of the Prime Minister, when the office of the Prime Minister falls vacant. And here it's provided that the office of the Prime Minister will become vacant if the holder of the office is either dismissed by the President, or B, if he loses the National Assembly, his seat as a member of the National Assembly, as provided under Article 103 of the Constitution. So Article 103 of our current Constitution prescribes for removal of a member, or how a member of Parliament's seat falls vacant. So if this happens, then that would create a vacancy in the office of the PM, or if the person resigns from office in writing to the President or through impeachment. Next slide. Then we have another article. The next amendment proposes to insert another article, which would be 151D. And this new article provides for the process of appointment of deputy prime ministers, and what would cause those offices to fall vacant. So the functions that are provided according to this bill to the deputy prime ministers is that they're required to deputize the prime minister in the execution of his functions, or undertake any other functions that may be assigned to them. Then the office under subclause 3 of this clause, the office of a deputy prime minister will become vacant if the person is also dismissed by the president, ceases to be a member of parliament, ceases to be a cabinet minister, or resigns in writing addressed to the president. So you will see later that yes, the person who will be the persons who will be appointed as deputy prime ministers will be from among the cabinet ministers. So if the person ceases to be a minister, then it's one of the grounds for which that office will fall vacant. Then the next clause of this bill, which is clause 29, proposes to amend Article 152 of the Constitution, and currently Article 152 of the Constitution talks about the composition of cabinet, and 152.1 provides that this is not the current constitution, that the cabinet consists of the president, the DP, the attorney general, and not fewer than 14 or not more than 22 cabinet secretaries. And now I know that the cabinet secretaries will be cabinet ministers if this is passed. So the first amendment here provides that, and it inserts that the following new paragraphs immediately after paragraph B. So after the deputy president, then it inserts the words prime minister and deputy prime ministers. So it will now read that the cabinet consists of the president, deputy president, prime minister, deputy prime ministers, and then the list continues. Then the next amendment alters the words cabinet secretary to cabinet minister. I think we've already discussed that. Then in clause 2 of this, clause 2 provides that it deletes the words nominate and with the approval of the National Assembly. So here, the current constitution reads that the president shall nominate and with the approval of the National Assembly, appoint cabinet secretaries. So those words nominate and with the approval of the National Assembly are deleted. And effectively, it will read, the president shall nominate, the president shall appoint cabinet secretaries. So it effectively removes the requirement for nomination and approval by the National Assembly. Then it adds the provision that the cabinet may be appointed from members of the National Assembly. Cabinet ministers may be appointed from members of so this reads that, currently it reads that by deleting the words substituting therefore the following words, the cabinet ministers may be appointed from among the members of the National Assembly. That's under subclause 3. Then this same clause, clause 29, it adds clause 11 that the cabinet shall remain in office until the president-elect assumes office. So if I go to, currently the current Article 152 has 10 clauses, and it ends at if a resolution under clause 9 requiring the president to dismiss cabinet. So this clause provides for, this article provides for the nomination and approval by the National Assembly of members of the cabinet. So currently there is no provision, it does not provide for that the members of the cabinet shall remain in in office until the next president-elect assumes office. So this is an addition of a new clause which requires that if an election is held, if an election is held until the next president comes in, then the previous cabinet shall remain in office until the next president-elect assumes office. So if I go to the object of that, the main objective of that addition, it provides that the tenure of office of the cabinet is provided, outlining that the cabinet remains in office until. So this is just to provide more clarity in terms of the tenure of office of the cabinet, so that it lapses once the new president-elect assumes office. Then if we go to the next clause, which is clause 30. Clause 30 of the bill proposes to amend Article 153 of the Constitution, which is on decisions, responsibility, and accountability of the cabinet. So currently, as it is, cabinet secretaries are accountable both individually and collectively to the president for the exercise of their powers, and to the president only. Currently, that's what it reads. So with this new, if this bill passes, then there's requirement. There'll be a requirement for them to be accountable to the National Assembly. I know they still can be summoned and do go to make various representations before the Parliament when called upon, but this clause is providing clarity that they are also accountable to. They will also be required to be accountable to Parliament in the execution of their functions. So this is one of those amendments that we thought was a bit progressive, because it enhances accountability, as opposed to the others, which seem the other two that I've mentioned that seem to remove, for instance, the vetting requirement, thereby limiting accountability and causing, and also limiting what is separation of powers. So that's one, in our view, that's one that was a bit progressive. However, the second part of this amendment, Article 153, by deleting whereby. Okay, no, that's fine. Then we go to the next, which is under clause 31. It inserts 153A and creates the Office of Deputy Prime Ministers. So under Article 153, after decisions and responsibility of the cabinet, then we will have a new article which will create the office of which will create the office of deputy ministers. So the president, this is not for the deputy prime minister, this is specifically for deputy ministers. The president may appoint not fewer than 14 and not more than 22 deputy ministers. So previously we did not have, our current constitution does not have this position of deputy ministers. So this amendment provides that they may be appointed from the National Assembly, and they'll be accountable to the President and the National Assembly in the exercise of their powers and performance of their functions. The main object, according to the bill, the main object of this inclusion is that these deputy ministers will have, their main functions will be to deputize the cabinet ministers in the execution of their functions. So this is sort of going back to to what we had under the pre-2010 constitution, where we used to have ministers and assistant ministers. So effectively, this is also expanding the cabinet. So other than adding the position of the prime minister and the two deputy prime ministers, we've also seen that now there's an addition of deputy ministers who will be not less than 14 and not fewer than 14 and not more than 22. And they can be, their functions are as provided, and they can be reassigned or dismissed by the president. So yeah, we can move to the next. Then clause 32 of the amendment bill proposes to amend Article 154(2) of the Constitution. So Article 150 proposes to amend Article 154(2) of the Constitution by deleting the words nominated and with the approval of the National Assembly. So again, this proposal or this amendment will remove the vetting and approval by the National Assembly for the Secretary of the Cabinet. So currently, Article 1 the Secretary to the Cabinet, and as it is, the Secretary to the Cabinet shall be appointed, is required to be appointed and with the approval of the National Assembly, appointed by the President with the approval of the National Assembly. So if this amendment goes through, then the President will not be required to put that name before Parliament for their vetting and for them to make the decision as to his suitability. It basically removes the words nominated and with the approval of the National Assembly. So it will read that the Secretary to the Cabinet shall be appointed by the President. Then he may also be dismissed by the President. Then this again seems to limit accountability, because the main reason why that had been included in the current Constitution is to ensure that there is a check. Even though the President makes that nomination, then Parliament checks and then vets. But that will be done away with if this goes through. Then clause 33 as well, it proposes to amend 155.3, and 155.3 talks about principal secretaries, talks about the office of principal secretaries. Currently, each state department is under the administration of a principal secretary, and Article 155.3 of the current Constitution talks about the procedure of nomination of a person as a principal secretary, and it also has that requirement for nomination, that the nomination shall be done with the approval of the National Assembly. So if this amendment is passed, then the President shall appoint principal secretaries from among persons recommended by the Public Service Commission, and the provision, just like in the previous clause, the provision for vetting by the National Assembly will be done away with. So that's under 155.3. Then clause 34 proposes to amend Article 156.4 of the Constitution, which requires the Attorney General to perform, and now it will require the Attorney General to perform functions of a cabinet minister. So if you look at clause 34 of the bill, it provides that the Constitution is amended by inserting the words functions of a cabinet minister immediately after the words shall perform. So currently what it reads is that the Attorney General shall perform any other functions conferred on the office by an act of Parliament or by the President. So if this amendment passes, then it will read that the Attorney General shall perform the functions of a cabinet minister and any other functions conferred on Parliament. So it basically just adds that the AG will be required to perform the functions of a minister or any other function that may be assigned. Then the next is on clause 35, which proposes to amend Article 157.3 of Article 157.3 of the Constitution regarding the office of the Director of Public Prosecution. So currently it reads, 157.3 reads that the qualifications for appointment as a DPP are the same as that for the appointment as a judge of the High Court. So what this amendment is proposing is to replace the words High Court with Court of Appeal, which would mean that the person appointed for the as Director of Public Prosecutions will need to have the same qualifications as a judge of the Court of Appeal. So it's basically raised the qualifications requirement. And if you look at the main objective that has been provided, is that it's to enhance the qualification for appointment to that of the Court of Appeal, I think, to provide for uniformity with holders of other independent offices. Then clause 36 repeals Article 158 of the current constitution, and Article 158 basically provides for removal and resignation of the Director of Public Prosecutions. So the entire article is repealed, and so basically the entire Article 158, if this amendment passes, is removed. And the reason for this is to align the removal and resignation of the Director of Public Prosecutions with that of other constitutional commissions and independent offices. So removal will be same to that of the offices under Chapter 15, and this is to reflect that the office of the DPP is proposed to be included as an independent office under Chapter 15 of the Constitution. So currently the office of the DPP is listed here amongst offices under the executive, but if this amendment passes, then what it would mean that the DPP's office will be under the other independent offices that are listed under Chapter 15 of the current Constitution. So I think that's it for the main amendments regarding the executive. So we've seen, just move to the next, Leo. Yeah, sorry. So it basically introduces some new offices. That's the office of the Prime Minister, the Deputy Prime Ministers, the Deputy Ministers, provides for their roles, and then it makes this amendment regarding the office of the Director of Public Prosecutions. So that's it for the amendments. We go to Chapter 12.
Okay, thanks, Jackie. So let's go to Leo. Leo, you have 20 minutes, so please go ahead.
Okay, so I discussed the amendments to Chapter 12, and I'll also switch off my video for the purposes of the bandwidth so that you can be clear. So, Chapter 12 of the it starts from the Article 201 all the way to 231. So the first clause that amends Chapter 12 is Clause 49 and amends Article 202 by introducing Article 3, which requires that the most recent audited accounts of revenue submitted by the Auditor General shall be taken as accounts of revenue for the purposes of revenue sharing if Parliament delays on approving audited accounts. So you all know, I think that this is one of the most progressive constitutional imperative that is being introduced in this chapter. You all know the problem that Parliament has been sitting on the audited accounts for national government, and which have been used, which are required by the Constitution for use of in revenue sharing. So that delay, we normally have almost a 3-year delay for approval, so that when the revenue sharing discussion for 2021-22, the Parliament has not yet approved for 2018-19. So, and that is what this constitutional amendment is seeking to cure. On Clause 50, it's amending Article 203 by introducing provisions L, M, and N in 2031. So this Article 2031 talks about equitable share, and so the principles for sharing equitable share, and they're introducing L, M, and N to. So the first one, L, the need to eradicate corrupt practices and wastage of public resources. Secondly, also the need to ensure that attainment of Article 43 rights, the economic and social rights outlined under Article 43. And then the third one is the need to ensure that average amount of money allocated per person to a county with the highest allocation does not exceed 3 times the average amount per person allocated to a county with the lowest allocation. So, two things to note that the first thing to note is that the first principle and the L and the N principle, which should have are also progressive, but should have been drafted in a way that to as a standard, as a principle. But this one, if you see, for example, N requires, it's like a rule, which that requires that the highest county, which the county with the highest allocation should not be 3 times more the county with the lowest allocation. If you look at other clauses, like for example in 203G, that economic disparities within among county, that the revenue sharing should consider economic disparities within among counties and the need to remedy them. What the future scenario could suggest that when the more other counties would have, like what we consider small counties now, become big counties and are able to have more revenue and be able to self-sustain, the larger counties, which could lack in development also, would be in a point of a disadvantage. So L and N should have been written in a way that it's a principle, so that it takes care of all counties, that counties irrespective of whether it's a large county or a small county. And the one on fiscal prudence, fiscal discipline, is also a very progressive requirement, so that counties know that anytime that, for example, when they get adverse opinions or disclaimer of opinions in the way they manage resources, that the revenue sharing formula they shall be disciplined for being not being able to satisfy the financial principles as outlined in Article 201. Article 203, amendment to Article, so Clause 50 also amends Article 203(2), which raises county minimum shareable revenue from 15% to 35%. Also, and this one is also a very progressive constitutional principle, because it raises counties' revenues automatically. Because at present, if you look at if, for example, when Kenya will be able to collect ordinary revenues of Kenya shillings 2.2 trillion, the county revenue at that time would be around Kenya shillings 770 billion. If there is no amendment at this level, the county revenues at the most that counties, if it remains at 15%, the most that counties can get is around that 400 billion. So counties will be able to get more money from this principle, from this amendment. And I know the discussion in the public sphere now is that this amendment will not change much, but it will, because even if you look, for example, at national government those functions that are shared between national and county governments, like for example, agriculture, the national government is supposed to do policy. At present, if you look at the money that national government remains for the function of agriculture, it's still a lot of money, and the aim of this this principle will ensure that counties are able to get more money. Clause 51 amends Article 204, and Article 204 is on the Equalization Fund. So it's changing the timeline and by extending it from 20 years to 30 years from the promulgation of the Constitution of Kenya 2010. So it will increase because we have this will increase the time that is required by that this article, that from it increases the time that prevents Article 204 from expiring, because it's supposed to expire 20 years after 2010, that is 2030. But if this amendment goes through, it will go up to 2040. So, as noted in last week, 2048 is also amended to take into consideration the way in which Senate votes. As you all know, the structure of the Senate, the composition of the Senate will change once this amendment goes through, and the Senate will no longer be voting through delegation, because Article 123 will have been repealed. So 2048 will read that legislation under Clause 7, which is now the Equalization Fund, shall be supported by more than half of members of National Assembly and more than a half of members of the Senate. Previously, in the 2010 Constitution, it reads all county delegations in the Senate. So the voting by delegation has been removed. Clause 52 introduces Article 206A to Article 206 by establishing Constituency Development Fund. So this is another. You all remember that the 2010 Constitution phased out the CDF, and members of Parliament tried putting it in the Constitution. They couldn't. They had to find ways establishing CDF as a national fund. In this Constitution, the CDF, as per the Constitutional Amendment Bill of 2020, the fund is required to be used for performance and implementation of national government development priorities set out in the national budget within the constituencies. And also, so they also say that there'll be a legislation that will prescribe how the management of the fund, including public participation, shall be done by the residents in a constituency. So another Clause 53, amendment to Article 204B. 204B and introduces the County Assemblies Fund. 204B, if you look at 204B, it talks about 207B. It talks about the revenue funds for county governments. So at 207B, it provides for establishment of other funds by counties. In the 2010 Constitution, provides for the establishment of other funds by counties and management of those funds. Now it will read that provides for the establishment of county assembly fund and management of those funds. So an act of parliament shall be done for that purpose. So if there's a major governance question that talks about why would MCAs, whether there's collusion between members of county assemblies and the county executive, because county executive still controls the funds still are the ones who will sign off for funds of county assemblies. Now this proposal will set up a county assembly fund that will be managed by assemblies themselves. So it brings that distinction in terms of finances, county finances, because funds which have already been appropriated for county assemblies will no longer be managed through by officials in the county executive. This is a good proposal for those people who work in the governance for the purposes of governance, because it creates distinctions between the two. Clause 54 introduces 207A immediately after 207 and introduces Ward Development Fund. So, and the Ward Development Fund, it will be used for all county finances. 5% of all county government's revenues will be paid into the Ward Development Fund each year. Now, this fund shall be used for the only development expenditure, and this it will be used for functions of county government within county wards, and also emphasizes that it will facilitate the actualization of rights guaranteed under Article 43. So also an act of parliament should be done for the management of the fund. That act of parliament also will detail the criteria for disbursement of funds to each ward within a county, and also how public participation and identification of projects will be done. Clause 55 amends Article 215(2) of the Constitution of Kenya 2010, and it changes the composition of CRA by limiting the numbers that can be appointed by political parties from 5 to 2. The overall number as presently constituted, the CRA has 9 commissioners. The number is not going to change, but they're proposing the one person appointed by the president, a chairperson who is appointed by the president, 2 members nominated by political parties in the National Assembly. So it's amending C 215(2)C, which in 2010 Constitution reads 5 persons nominated by political parties represented in the Senate. Now, the parties represented in the Senate will only nominate 2, and those 2 people will be 1 man, 1 woman. And it now proposes a new addition, that there will be 2 persons also appointed by county governors and 1 person appointed from the statutory body for regulation of accountants, which in this case would be ISPA. So the rationale for appointing the one person from the statutory body for regulation of accountants is not clear, because the CRA deals with public finance questions, and I think also it's limiting that to one body. Clause 56 amends Article 218 and adds a new clause 3, that if CARA has not been passed by Parliament, COB might authorize withdrawal from consolidated fund of up to % of equitable share under Article 203 and dispersed to respective revenue funds. I think this clause in itself, because is putting it in the Constitution, is because one of the things that the Supreme Court had advised in the advisory when county governments went to the Supreme Court seeking an advisory, because it's in using the benefits principle. It's difficult to deny county funds when CARA has not been passed, and CARA is not within the reach. Whether CARA passes or not is not within the reach of county governments. It's something that is within the determination of Parliament. So this one is also a very progressive principle. Clause 57 amends Article 220 by adding B, requiring adherence to Article 21(2). 21(2) requires the state to progressively ensure that 21(2) requires the state to progressively ensure that rights as outlined in Article 43 are implemented. So it's implementation, and Article 21, implementation of rights and fundamental freedoms. So 2 says the state that shall take legislative, policy, and other measures including setting of standards to achieve realization of rights guaranteed under Article 43. So this one requires that adherence by giving an explanation of previous, current, and proposed budgetary measures. So in the budgeting process, so it's fixing national treasury and county treasuries, and also the National Assembly, the Parliament, and county assemblies, to ensure that these fundamental rights, as outlined in under Article 43, are progressively put into the budget, because article are progressively put into the budget, so to ensure that to ensure that we are able to realize, Kenya is able to realize those rights as outlined under Article 43. So also, Clause 57 amends requires that the form and timing and the content of national and county budgets shall be prescribed by national legislation. In the 2010 Constitution, it only required county budgets to be prescribed by national. The form, timing, and content of county budgets to be prescribed by national legislation. This one is, I think, for the purposes of uniformity, by requiring that the national and county budgets all shall be prescribed by national legislation. Clause 58 amends Article 224. So removes the limitation that county governments can only prepare a budget only on the division of revenue bill passed by Parliament under Article 218. So I think this is also what this provision is trying to cure is what happened last year, that county governments went ahead and prepared. The Constitution requires under Article 224 for county governments to prepare budgets on the basis of DORA, of division of revenue bill, which is so. If DORA had not been passed and counties had prepared budgets, so it means you cannot prepare budgets. But this one removes that limitation and allows counties to go ahead and prepare budgets based on a figure that they can project from the 3-year basis of sharing revenue. So it removes that limitation to only when DORA has passed, because the friction of back and forth between either both houses or senators in one or Senate or in the Senate cannot affect the operations of the budgeting processes in the counties. So Clause 59 amends Article 225(3). So Article 225 is the control of public money, and so it empowers the cabinet minister for finance to stop transfers to any entity for serious breaches or persistent breaches. So as if you look at the now that 225, so that 2253 that it reads in the 2010 Constitution, legislation under Clause 2 may authorize Cabinet Secretary for finance to stop transfer funds. So it's a condition. This one makes it mandatory. So by removing, because by empowering the CS, because for example, as present, the Public Finance Management Act requires the Cabinet Secretary to stop transfers to a county or a national entity or any state entity for if they get consistently, for example, disclaimer of opinion, which is that the Auditor General was not able to provide any opinion because there were no records in the first case. So if you are able to get, which is a serious breach in management of financial resources, or management of resources. So this empowers the CS Finance, the Cabinet Minister for Finance, to directly intervene and be able to stop that transfer of funds. Now, adds 3A to Article 2253 by giving 30 days to Cabinet Minister for Finance to notify National Assembly for stoppage of funds to national entities, or Senate in the case of counties. So the CS Cabinet Minister for Finance will stop funds in case of national entities by it notifies the National Assembly, but in case of county governments, notifies the Senate. Personally, and I think the 30 days is a lot of time, because the nature of public services offered by either national entities or county entities requires that these notification has to be immediate. I think it should not be more than 48 hours. So 30 days is a lot of time, and that one can affect public service delivery. So the rationale in putting 30 days, requiring the Cabinet Minister to notify Parliament, is a long time. Clause 60. If you, just to give an illustration, if we are spending $30 billion per annum, 3 trillion, we are spending close to 7.5 billion per day. That 7.5, you can, if the Cabinet Minister takes 30 days to notify Parliament, for example, on an expenditure of 30 billion, which could affect service delivery, that's an issue of concern. Clause 60 amends Article 228(1) to make the Senate as the confirmation house for the CRA chair. Article 228 now, at present, makes the confirmation for the CRA chair is done by the National Assembly, because it reads that the control of not for the CRA chair, the controller of budget shall be nominated by the President and with the approval of National Assembly, appointed by the President. So in this case, Article 228 makes the controller of budget, makes the confirmation process for the controller of budget to be done by the Senate. Clause 61 amends Article 230, which changes the composition of SRC to a 7-member commission, which includes a chairperson and 6 members, nominated by the President and approved by the National Assembly. So it deletes clause 233 and 233. So 233 is that the commissioners under Article 1D and E, Article 1D and E, which is one person nominated by CS Finance and the Attorney General, shall have no vote. But given that already Article 232A, Article 232 has been amended, membership of the SRC has been amended, Article 233 is no longer relevant. So that deletion is automatic. So Article 234 is also amended by adding C to expand the mandate of SRC to determine the rates of consultants under national and county governments for services rendered. As you all know, one of the complaints about procuring human resource, and this is consultants, to be consultants, lawyers, is that the bills that government agencies have been charged are horrendous, and I think one of the things that came out from the public hearings is that that mandate of SRC has to touch on those specific, so those consultancies that are being done by national and county and county governments. So it adds CA to Article 235, which adds another principle for SRC to rationalize and harmonize remunerations paid to all public services, all public servants. So I end my presentation there.
Okay, thanks a lot, Leo and Jackie. So basically, they've taken us through Chapter 9, which is specific arrangements, specific proposals in the Constitution Amendment Bill. And let's remember, this is the second bill, the Constitution Amendment Bill 2, which was published last year in October, seeking to introduce the office of the cabinet, introduce the office of the Prime Minister and 2 Deputy Prime Ministers. I think an important thing to clarify is that the press reporting is as if the cabinet ministers, or rather the Prime Minister, would be appointed from outside Parliament. The Prime Minister would be a member of Parliament and therefore would be similar to what we had in the 2008 to 2013 season, when we had a Prime Minister who was both a member of Parliament and at the same time sitting in cabinet. For that reason, it's not very easy to see what effects it would have on public budgets, especially on Parliament side, though it obviously would have implications for the executives, the size of the executive. But even that maybe not, because the number of cabinet secretaries, the number of cabinet ministers, or cabinet ministers as they'll be called, has not been changed from 22. So whatever it is, there'll be some really serious rejigging that the president would have to bear in mind. Then Leo has taken us through Chapter 9, or rather Chapter 12, which deals with public finance, and basically this is the chapter on the budget. We need to admit, as the Institute of Economic Affairs, maybe we should go on the record that at the Institute of Economic Affairs, we actually made presentations to the task force because there's a public call for participation. So as the IEA, we prepared a presentation and we made a specific proposals to the task force, especially with regard to Chapter 12 and the Bill of Rights, which we thought were some of the areas in which the IEA saw concern, and which in our thinking would be consistent with what the original 9 objectives of the BBI were. So I think that's important for us to say. So for that reason, we've closely tracked the BBI process itself, and obviously the Constitution Amendment Bill, and this is part of trying to ensure that we try to close that gap. We close that circle. So that's important. We place this every so often. So for us, the partisan discussions about BBI and all that is all right, but we have to admit, as the Institute of Economic Affairs, that I and a couple of colleagues prepared representations and also prepared a policy brief which we sent. It's available on our website, but whoever wants to can get a copy of all the presentations that we made. I think it's just important for disclosure, but also to think that these were open public processes in which we participated. So I think there are material changes in terms of how the executive will look. And as my colleague Jackie said, our intention is to provide the public education. But let me say what, in my view, will happen. I keep saying that the BBI has what you call the good, the bad, and some ugly parts. My colleagues don't mention what the ugly parts are, but I think they are. But one of the things that the BBI, or rather, the Constitution Amendment Bill, as proposed, would do, is that it's as if, as Kenyans, we will have to rethink our view. As Kenyans, we'll have to rethink the intention that we intended to have a presidential system. Because what the changes that Jackie has highlighted to us, specifically a new prime minister and the relations between parliament and the executive branches, will not be as neat as the divide has been. And in my view, that's one of the things that Kenyans took a significant decision upon and decided that a presidential system is a superior system. So it's as if right now we are back to mixing it up. So we'll probably have a mongrel of a sort, or something that has the head of a donkey and the backside of a zebra. It seems like the political compromise that is being suggested to us is basically to fuse those two houses again. Whatever might be the reason for that, it also means that it's something that also the members of parliament, in our view, are making a mistake about. But many of them are minded to think that there's an incentive that some members of parliament will also sit in the cabinet. Bearing in mind that there are only 22 of them, for an expanded parliament that will be maybe mostly up to 300, more than 400 people, we don't think that the mere incentive that some of them might be appointed as cabinet secretaries is good enough reason for them to wish to surrender, in our view, would be the very clean division between the executive on one side and the parliament on the other, especially because regardless of the fact that we've had a constitution for 10, 11 years now, that separation of powers is one of the things that the parliament has handled the poorest. So it was still taking cues from the executive, and the executive also believing that its work is actually to influence government. To influence the operations of parliament. So that thing has not been resolved, and we are thinking that one of the things that the Constitution Amendment Bill is doing is actually going back to it. So my view would be, if Kenyans, for any reason, because we think that coalitions are important, or because we think that there's a fracture, and we needed to fuse political systems, and our preference is a Westminster type government where you prefer prime ministerial system, then it should be stated. But what we are trying to do, which is typically Kenyan, or perhaps because we do not want to admit what the choices before us are, is that these proposals would significantly dilute presidential system. So it will neither be a presidential system nor a prime ministerial system. So you have an elected president, and then you have a prime minister performing certain symbolic functions and also beholden to the president. I'm not too sure that solves the problems that we are thinking about, even if it's a fairly symbolic gesture. And for whatever it is worth, we should be clear to Kenyans that there's now some conceptual confusion about whether Kenya retains the presidential system or not. So that's one. On the public finance side, I think the most critical ones is clause 49, which is the 35% rule. Leo explained it, but I would like to explain it again because, again, we think the public discussion around it is a bit woolly, if not entirely confusing for those who have not read the text. So let me say this. In the proposal that the IEA made to the task force on the BBI and the professionals who are required to get views after the task force report was published, the IEA, based on studies that we've done at the back here and discussions that we've had even with county governments and offices, it is clear that the amount of money that the National Assembly votes every year to counties is little. It's insufficient. And I'm leaving aside the question about the integrity of the systems of the county governments in terms of managing money. But the amount of money that is available for the kind of constitutional obligations that county governments have is too little. So it needed to be enhanced. And we made that proposal that it needed to be enhanced. And our view was that it could be done progressively. However, the politics of the last 12 years shows that the National Assembly, to be honest, has taken upon itself the role to put governors and counties in their place. And some of it is just basically, we will not give this money because we do not want to give it and because for whatever reason, aligned with the executive. So the compromise was then, a number was picked. We don't agree with it, but arbitrarily this 35% was picked. Now, what that means, I need to clarify this because the public debate, to be honest, is what that means is our argument was that 35% was insufficient because, rather, that 35% is the 15%, which was a floor, was insufficient because there were two roots. One, the fact that the parliament had fitted into the constitution of 2010 the caveat, which was that all public, or rather the division of revenue between national government and county governments would be based on the latest audited funds, which Parliament is right now 2.5 years behind on, which means while the national government plans according to what its suggestions would be on revenues this year, county governments are beholden to a ratio that is determined by at least 2 or 3 years back of audited accounts, which the Auditor General's office has completed, but which Parliament itself, again, the National Assembly itself has not approved on time. So obviously there was that mischief which needed to be fixed. So that was the first. So what Leo said is that basically what has happened is a proposal that we gave ourselves, perhaps other people did, was to make sure that counties are not punished, or at least do not see delays based on a process that they cannot control, which is the approval of budgets. To basically to reset it in such a way that both the national government and county governments will be distributing revenue based on what the assessments are every year. That also gives an incentive for both the National Assembly and the Treasury. I mean, for both the Treasury and the Revenue, Kenya Revenue Authority, to assess what the real revenue prospects are for the year. So that's what this is setting. So that's the first. The second part is there are many functions that were assigned to national government, between national governments and county governments, to county governments, which the national government still retains. Say, for instance, healthcare. We still ask the question, and it's a mystery to us, why the Ministry of Health spends on its own close to 1/2 of what all county governments together spend, when it does not provide frontline health services and only manages, I think, 4 facilities, which are the 2 national hospitals, 2 referral hospitals, and the referral hospitals and the spinal injury hospital and a few other facilities which are at the universities. So obviously disproportionate, the division of money is disproportionately in favor of national government with respect to health services. So that is one of the things that would have to be resolved by both perhaps redistributing the cash, but also perhaps staff, which are all difficult political compromises that need to be made. The press is making it look like the 35% rule would require additional money to be added and to keep the national government portion of it as it is today. That is not necessary, and that is not what the strict reading of the regulations, according to the golden rule, would be. So there's a little bit of mischief or misunderstanding, but that's essential for us to clarify. Now, I know we are quite behind on time, but I'll open up for the next couple of minutes for those who have questions to ask, and then we can ask Jackie and Leo to respond to that. Do you have any questions? Please raise your hand, switch on your camera, and then you can ask a question. Any questions? Is the chat box open? Any questions? Well, we don't have any questions, and I don't see any hands up. So what I'll do is then I'll ask Jackie and Leo to just make any concluding remarks or to clarify anything that they felt was hard because of the timing.
There are questions in the chat box.
How comes I can't see them? Okay. I can't see any of them, sorry. Okay, let me see. Can someone read them out for me? Let me find out. Let me just find out how to, because I can't see any questions in my chat box. But let's get the Jackie and Leo. Please just read out the questions, and then you can answer them as I try to fix my chat.
Okay, I think if you scroll down on the chat box, you'll see the questions. Right down. I think the first one here is clause 54. Leo, probably this is for you. Recognizes the allocation to boards and thus likely to attenuate intra-marginalization. A possible response to failure by county leadership to promote equitable development within a county. Is it correct to assume that it is more beneficial with relatively less words? Would be good to see the simulations using current baselines. Good presentation. I think this first one, Leo, you can respond to it as I scroll through the next.
Yes, Abdirahman, it's correct to note that the allocation towards is a failure by county leadership to promote equitable development. And there's this thing that is very popular in Kenya, that development, that we need development, we want. So, and by saying development, people want to see buildings, roads, some kind of something that is tangible. However, I think if the good thing about that, what should happen per se, is that county government, the functions as outlined under Schedule 4 of the Constitution on the part of county government, county should only focus on public services, the ones that improve the welfare of the citizens, and limit themselves to that. However, because the issue of equitable development is very broad and very development in Kenya is not a very, if we are talking about public services, that's what one needs to improve. Your issue about whether this one will benefit counties with smaller wards, with fewer wards, is also a very good observation. But however, one of the counties, now this is from practice. If you look at some countries like the US, for example, they have 50 states, but have more than 3,000 counties. Those are local counties. So it's possible to provide public services at the most micro level. The size does not matter. It's that efficiency of government. But when government is limited to fewer things, so it will be good to see simulations from using the current baselines. I think that would be a good thing. So, Jack, back to you, Jack.
Okay. I don't see any question here related to the executive, but I see William asking, Hussein Diro asked, please clarify how BBI proposals arrive at more constituents, yet it's IBC's mandate. We have legislation on delimitation of new boundaries based on 2019 census. So our presentation today, Hussein, was looking at two chapters, the one on the executive and the one on public finance. In our last presentation, we will do a presentation on all the other amendments for the rest of the chapters. This should be under chapter 7. Representation of the people is under chapter 7. So it will form part of our next presentation. So the question on any amendments that are proposed regarding representation regarding the IEBC, we'll do it at the next our next and last webinar. However, if you look at the legislation proposed under the first schedule of this bill, this amendment bill proposes that legislation for various laws to be enacted by Parliament to effect the changes. And legislation on elections, that's Article 82, 87, 88, 90, and 97, should all be done within 6 months. I do not see the requirement for amendments on Article 89, which is on delimitation of electoral units. So delimitation of electoral units is on it's currently under Article 89 of the Constitution, and it's not provided here as one of the pieces of legislation that is recommended and under this bill. However, just for clarity, the rest of our presentation regarding representation will come in the last in our next webinar. So it did not form part of this discussion today. I think the next question is for you, Kwame. I don't know if you are now able to see the questions.
Yes, I am, but I can't see which question are you. Yeah, I can see the question. So I think Hussein asks, please clarify how BBI proposals arrive at more constituencies, yet it is IBC's mandate. We have legislation on determination of new boundaries based on 2009 census. Jackie, can you answer that?
That's what I was responding to right now.
Okay, that's fine. So what's the next one? Abdurrahman asks, looking at the presentation, the proposal seems to increasingly ring-fence allocation and codifying the same in the Constitution. What is the impact of this? Yes, on effective public sector budgeting as a whole. Any risks? Yes, I have comments, but let me ask Jackie and Leo to respond to that as well first. Jackie or Leo, what do you think about what is the effect of ring-fencing? Ring-fencing allocations to every sector within the Constitution itself.
Yeah, so for me, what I think is that this is just another way of it's doubling bureaucracy, because if we have a national budget and priorities, but still put them into separate, now put Ward Development Fund, puts again the Constituency Development Fund, and then consequently, because what should happen is the planning should be at micro level, but and in the implementation likewise, but fixing those funds in specific as a problem, because a constitution is static, it's sticky, like it will stay. They'll be, if for example our national budgeting priorities change, but still we will still, like at county level, the budgeting priorities change, but still we'll be required to put 5% of all county government revenues into a Ward Development Fund. It makes it very difficult. These prescriptive rules should not be in the Constitution. We should only have constitutional imperatives, which are like constitutional principles, and then now we can do the rest through regulation and the statutory law. But these prescriptive rules, especially around budgeting and funds, is not an efficient way of doing budgeting.
Okay, Jackie, do you have any other comments?
I don't have any additional comments to that. I agree with what Leo has said.
Right. Okay. Let me add. I can't see there's somebody with their hands up, and I can't see it here, so I'll get the list of those. Something's definitely wrong with my system today, but I'll try and get the. But let me add something to. There are risks. There are definite risks to ring fencing, especially within a constitution. Certain amounts of money to be spent on certain things, because if we agree as Kenyans that development is important and it's important all the way to the ward level, then the question about how much money you allocate should be a budget question through the PFM Act. What we are seeing here is the tendency to cut off portions of the budget. I mean, portions of future spending, and dedicate them to place them in a fixed way within the budget itself. Instead of having them as a budget question to be determined every year, you simply decide that 5% of all budgets should be spent on wards and another 5% on CDF and all that. The problem with that is that, one, the real risk is, for instance, we think at the Institute of Economic Affairs, at least our PFM team, that part of the reason Parliament has been unwilling, especially the National Assembly, has been unwilling to control huge public deficits, which then result in debt, is because of this rule. We think it's unconstitutional, but because of this rule on CDF, where the national government CDF is permitted to spend at least 2.5% of all incomes, of the total budget spending within counties. I mean, within constituencies, as what is called the national government national government CDF. The problem with that is that it makes members of parliament work on both sides. And I think the conceptual problem is what we have with Kenya's constitution, that parliamentarians, instead of being oversight institutions, being the guardians of the public purse and public taxation, want to be involved in executive functions of implementing projects. For as long as we have that confusion, and parliamentarians deciding to want to step on both sides, we'll have the problem like we had yesterday, where parliamentarians were arguing that the year is ending and they have the final 3 months to go, and yet they're refusing to accept or to consider a supplementary budget because many of them have not seen the money that was promised to the constituencies under the government fund. So what you can see is that they're not coming to this debate with clean hands, but they're also thinking that the only reason we will refuse to discuss a supplementary budget is because the cabinet secretary has not sent money for us to construct schools and sanitation facilities within the constituency. So Parliament, as a way, is behaving as if while they are members of Parliament with supervisory role, with the oversight roles, they also want to be implementing and constructing schools in the same way. That's a really, really bad thing. And it's antecedents. It comes from the fact that before the new constitution was passed, cabinet secretaries used to be very, very quote unquote powerful. They were not as accountable, and Parliament could not keep them in check. And so for that reason, the only way parliamentarians could get themselves to ensure that there's a spread of spending in all constituencies is to come up with a constituency development fund. And that bad habit has now been kept within a new constitutional dispensation, and it's creating a confusion. And the reason I think it's getting worse is that's also part of the reason that many county governments, county assemblies went with alacrity and supported the Constitution Amendment Bill, because they were promised that in addition to that, there'll also be the ward fund, which they think that will also be responsible for. So in other words, legislators in Kenya do not think that they should only do legislation. We have introduced a very perverted form of pork barrel, where legislators want to be patrons and not only ensuring that construction, quote unquote development or construction or roads are built, but they also want to sit in boards where those decisions are made. And that's a very dangerous one, because it's confusing the executive functions from the functions of legislation and oversight. It's a mess, and I think it's going to lead us to much worse trouble, because they then don't have good faith to actually audit properly and to follow audits, because members of Parliament themselves have sat in committees in which decisions have been made in making expenditures which the Auditor General is now following up on. So it's very difficult for the Auditor General, for parliamentarians and parliamentary committees and the other and their counterparts in counties to actually follow with good faith the prescriptions of the Auditor General, because some of the findings suggest that many of them might also have participated in procurement decisions that are questionable. So we have a problem as Kenyans in that respect. Regardless of whether the Constitution Amendment Bill passes or not, I think that's something we need to really focus ourselves on, and to be conceptually clear about what the real roles of Parliament is. This stepping back and forth is a dangerous thing, and it's going to make public budgeting in Kenya a complete mess. So those are the risks, in my view. One of those risks is they're obviously stepping on both sides. The other one is they don't have an incentive to then control public spending because they have a share. And the other one is that it just reduces flexibility in the budgets, because if you have salaries to pay, 2.5% has to be given already to 15% had to be given to counties, and that was acceptable because rules need to be established to talk about the separation, the vertical separation. But now this horizontal separation, where money is being predetermined to specific areas. What if, say for instance, if you decide that money needs to be spent in every ward, what if maybe the bigger plan at the county level is actually to spend money in a different way, as opposed to just making sure that every ward has 5 million shillings to spend on a project? That's not good development planning, and that's not good development execution. And it's just one way of pork barrel, spreading money and giving people opportunities to corner public expenditure within counties, at the national level, constituencies and all that. It's a very, very bad thing, and it's something for which I'm personally very concerned at, and the PFM program of the IEA is as well. So now I think I haven't seen any other question. I saw, Stephen had a question. Please ask your question, Steve, before we close. Stephen Jairo, you had a question. I saw your hand up. Did you have your hand up, Stephen? All right. I think I'll have to close now. So let me have Leo. Let me have Leo. Okay, so Steve has a question here. Steve has a question here, which I'll ask Leo and Jackie to finish up with. So he's asking, what are the grounds upon which the president could dismiss the PM? And obviously, the question is, isn't this entrenching an imperial presidency? And then the second question is basically the deletion of nomination and approval by National Assembly, basically the vetting powers of the National Assembly being taken out for some offices. What are some of the effects of those? So I'll ask Jackie and Leo to make their final comments as you also answer this question. So let's start with you, Leo.
Yeah, yes. So the removing the provision that's removing the vetting principle for principal secretaries, secretary to the cabinet, and some of the cabinet ministers who will come from parliament, is basically that it's like removing some of the requirements from being a cabinet secretary, and lowering the bar, because one of the things that in a proper working democracy, parliamentary democracy, in a proper working democracy, people are able to be held accountable and be asked questions about what they've done before they are sent to an higher office, because a cabinet secretary has power to make rules, has power to spend, has power to predetermine so many things, and or even a principal secretary who is the fiduciary manager for ministry, and that is a serious concern especially for people who are concerned about the governance questions in Kenya at present. So that is a clawback from the previous constitution. On the question of the PM, also as myself, I'm still surprised, because the rationale for introducing a PM is to give some form of tenure into that office, so that at any point because the PM, the grounds for declaring vacancy in that office, one of them is that they can just be dismissed by the president. And the rationale for putting some tenure into it could have been that dismissal, for example, has to be confirmed by a majority of both houses, so that to give some room that even those even issues of disagreements, for example, cannot lead to a person leaving the office of the PM. So another question, just to make concluding remarks, is that the proposal some of the proposals, for example, like to add constituencies which are predetermining, for example, the limitation that will be done next year, which is the issue of multiple representation, the issues of questions, for example, like a doubling of this, of increasing the funds that are available for development, like constituency and ward development fund, is just doubling, duplicating responsibilities. My perspective, for example, on issue of parliament, of MPs, what we should just do is agree, for example, that MPs should only concern themselves with the issue of legislation. MPs should not manage any issue, any funds, because that is the only way that you can provide those checks and balances. Once MPs start managing funds or overseeing funds, they don't have the incentive or the initiative to provide those checks and balances. So, like the question of issue that has been raised on deficits, the MPs will raise this budget so long as we know under the law that 2.5% of that money will go to CDF. And it does not matter what we do. unless that separation of powers doctrine in the Constitution is clear, all these problems will still have problems and come back again to redo the Constitution. So that's my comment. Back to you.
All right, Jackie. Sorry, Jackie, before you answer, let me ask, I just received is Joanne here? Joanne has a question. Joanne Onyango, you say you have a question. Please ask your question. She doesn't seem to be here, so I think you should go ahead, Jackie.
Okay. So in response to Steve's question, in what instances would the Prime Minister be dismissed by the President? Now, unfortunately, the amendment bill does not specify specific instances. It's just the first ground upon which he may be dismissed, and it just reads that the office may become vacant if the holder of the office is dismissed. So I think that's again creating, leaving it to the discretion of the President, which it's expanded powers again, or increased powers for the presidency, if you ask me, because it's not provided. It could be anything that he decides or deems fit. But again, if you look at the provisions under Article 103, which is one of the grounds, Article 103 also points us to, amongst the many other grounds that are provided, it points us to the provisions on leadership and integrity. So if there's breach, any blatant breach of the requirements under Chapter 6, then again, by virtue of, if you link that back to Article 80 and Article 103 of the Constitution, then that may form part of the grounds. But in terms of the first subclause, which is 1A, it's not clear on what grounds he may be dismissed. So perhaps that's something that should be looked at. Then someone asked, what is the consequence of this increasing instances where we see Parliament's approval is not required? So what would that lead to in the end term? I think, as my colleagues have also already mentioned, it's basically watering down the doctrine of the separation of powers between the Parliament and the executive. So it's basically assigning more powers to the executive as opposed to the legislature. So, and with the lack of checks, then obviously there's reduced accountability, and we know what that would mean. Then, in my view, it's basically just provides for like an unchecked presidency, which, as we have seen in the past, then sometimes either goes to the effect of this is persons that are appointed or awarded or put in these positions sometimes do not meet the proper requirements. The accountability mechanisms are not adequate, and so sometimes you see either incompetency or lack of accountability in those offices. Then someone, I think, asked about what scenario, if we can be able to provide the scenarios if these amendments pass. So if I speak specifically on the added seats, the number of seats or the implications of the expanded executive, it's not manifestly clear right now what economic, the implications in terms of additional funds that may be required for that. We can try and calculate, but then remember that again, some of these persons may be appointed, as the amendment suggests, some of these persons may be appointed from people who are already members of Parliament. So it's not clear how many more outsiders may be appointed after. We can only wait and see what happens after the next election. But some may be appointed from within members of Parliament, which would mean that their costs will already be catered for and will not mean additional costs, apart from maybe a few perks here and there, which may not be very substantive. But we can try and do some calculations in terms of best case scenario and what would be the worst case scenario. But at the moment, what I can provide is I can state is that some may actually be from members of parliament, so it may not translate to much additional cost. So I think, unless I haven't responded to anything else, there's someone else who also asked about another question still regarding delimitation of boundaries and the additional 70 seats, 70 constituencies. What I would say again is that in our last webinar on this, we've had a series, this was the second. In our third and final webinar on this, which will come sometime next week, we will provide for all the other amendments to the Constitution based on, so far we've only discussed 3, so we'll provide for all the others in the last amendment, and representation of the people will be one of those. But if I could just state it here for your benefit, the requirement under the Constitution is that the delimitation should be done, delimitation of boundaries should be done at less than 8 years and not more than 12 years. So if the additional 70 seats, 70 constituencies are passed as is, then they cannot revise it. We cannot revise it again before another 8 years have passed. Because I think the question that I saw was what would stop them from adding any more seats if this passes right now. But we'll provide more details in our last webinar. So that's it from me.
All right. Okay, thank you very much, Jackie and Leo. And sorry, everyone, we took much more time than we intended to. I think about 20 minutes more than we hoped we'd intended to. So my view is, as you can see, there are these changes in the public finance chapter. And as I said, we own some of it because we made proposals. Now, it's not perfectly what we proposed, but nevertheless, we as IEA made proposals that some of which have been reflected, especially tightening expenditures, opening up opportunities for Parliament to perform its role in a strengthened fashion. In addition to the fact that I think in addition to the President talking about national unity and integration, among the things he should talk about during the State of the Nation is the progress that has been made in terms of achieving the economic, social, and social rights that are contained within the Bill of Rights, the broader Bill of Rights. And then obviously around the executive, we didn't make specific proposals for that because our view was actually that we needed more strengthened Parliament, but that the laws as they existed were adequate. But it looks like obviously with the other proposals that have come in, the reality is that this bill will be in Parliament from tomorrow for discussions, and there might be a referendum, the courts permitting. The function of the IEA here is just to make you understand what each of them means, what the proposals require, and to help you with some kind of list to help you know if you're having a discussion or just to understand the facts about what the proposals are all about. I think that's essential. If you have any questions, please don't hesitate to send them to the IEA through our admin address, and Jackie and Leo will have time to either respond by a blog or actually respond to you with the direct answers. As I see, we'd like you again to understand that there's a good, there's a good, there's a bad, and some stuff that's not very, very good, especially for us in terms of the weakening of the specific divisions between separation of powers between the executive and Parliament in general. That's something for which that chapter on the executive is one that we consider Parliament should actually look at very, very clearly, because then it would mean the place of Parliament in the hierarchy. As the Constitution of Kenya states today, we have separation of powers and arms are co-equal. I think the fight under this would be probably to restore the settings where we have a presidential system, or rather, we have a strong presidency or a strong executive, and Parliament would do its as it's told very often. So that's reason for us to be concerned. The public finance chapter itself, as Leo has mentioned, has some good and bad as well. But in general, if you consider what some of the proposals taken on their own, substantial improvement from what exists today. But all this depends on Parliament, which is the guardian of the past, and understanding its role and doing that one. So on behalf of the Institute of Economic Affairs, we are thankful for you to spending your time here. As my colleagues have mentioned, Jackie, we'll have another webinar of this kind sometime next week. We'll give you notice of that. And all the presentations that we have here will be placed on our website, and a link will be sent out to all of you so that you can look at it more keenly. But the most important thing is, I think, find a copy of the bill, the Constitution Amendment Bill. We could provide links to it if you wish to, and please read it for yourself, because obviously, whether it passes or not, it will be a monumental decision that Kenyans have to make sometime this year to change the constitutional landscape substantially, in our view. And at the same time, obviously, even the role of citizens and professionals in public life in Kenya. So thank you very much and have a good afternoon. Thanks.